states, "You think I'm crazy now? Y'all going to see how big my balls are."
I want the truth. You can't handle the truth.
You were Ryan Latino.
Yes, sir.
You were charged here with stalking. And go ahead.
Your Honor, I filed a writ. The bond is set at $100,000, which we're alleging is excessive, and we're asking for a bond reduction. That's for the reasons enumerated in the writ, and I'm prepared to elicit some testimony.
Go ahead.
From the defendant's mother.
Go ahead.
Therese Connolly, where do you want her to be positioned? Your
That's
Honor?
right.
Fleischer.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Yes, go ahead.
May I proceed, Your Honor?
Yes.
Would you identify yourself by stating your full name?
Sharice Noel Conley.
Ms. Connolly, how are you related to Ryan Latino?
Mom.
In connection with this writ hearing today, I asked you to get some information from different bondsmen. Do you recall that?
Yes, sir.
And did you do that?
Yes, sir. I did.
And which bondsmen did you contact?
Allied, Bell America, Professional Bell Bonds, and Outrage.
So actually you spoke with 4 different bonding companies, is that correct?
Yes, sir.
Now, did you make the inquiry of the first bonding company, which would be Allied, I believe, as far as what the financing and charges would be for a $100,000 bond?
Yes, sir.
And what did they tell you regarding what their bonding fee and financing options would be for a $100,000 bond?
$10,000. We would have to put down $3,000 and pay $500 to $1,000 per month with 2 co-signers.
Did you ask about what the cost of a GPS monitoring device would be in addition to the bonding fees? Should the court impose that with the bonding fees?
I did. I think they said there was a price to get it, but then it was like $220 a month.
So in addition to, if the court were to impose a GPS device as a condition of bond, there would be an additional $220 a month, but in addition to whatever the bonding bill was, the bonding payments would be. Is that
Yes.
right? If the court were to see fit to release me and make a no contact order with the alleged victim in the case, is it your opinion that Mr. Latino would follow that order?
Yes, sir.
But also communications, online communications, telephone, those types of stuff, any contact at all? Is your opinion he would follow that order?
Yes, sir.
Password, Sean.
Ma'am, were you aware that your son got into a fight in jail this weekend with another inmate?
Yes.
What did you know? What do you know about him?
I heard that he was trying to fight my son, and my son put him in a headlock as to not fight him, to defend himself.
So apparently that's something that he told you,
Yes.
but that's an incident that occurred this weekend right before he appears in court, correct?
Yes.
Are you also aware that he had another jail incident on March 21st? It's only been in there for just, what,
35 days.
35 days?
36.
Are you aware of that incident?
Possibly. I mean, we talk about a lot. I only recall this last one.
Where a nurse alleged that he was being rude and mistreating her?
No, sir, I don't know.
Never heard anything about that.
Yes.
Before I told you about that, would you have expected that conduct out of your son?
No, sir.
Certainly the stalking charges don't fit within the conduct you're aware of either, is it?
I am aware of the situation.
I meant you wouldn't expect him to actually stalk somebody.
No, sir.
Right.
Absolutely not.
So when you made the representation to the court that he would abide by terms,
Absolutely.
that's what you would have thought before the stalking charges came
Yes.
up as well. So how much money today does the family have to try to help him post a bond?
Yeah, Your Honor, I reject. It's not the family's responsibility. I believe under the law, it's the defendants. They're not required to. And as far as a consideration, it's not the family's financial.
I'll rephrase it. Has there been
What possible assets he may have?
If he has.
And
yes,
if
Your
the
Honor.
family is willing to help him, that would be an asset that he could possibly use. But go ahead.
So what's the amount that's been raised to try to get him out of jail?
Well, if the bond was dropped to 5,000, we'd be way better off to be able to help. Even 10,000.
My question was, what amount has been raised what amount do y'all have today to post for a bond?
I mean, we haven't discussed that. My
So
husband-
there's no dollar amount that y'all have.
Not at this moment.
Okay.
But we are willing to help.
Understand. That's what,
Nothing further, Your Honor.
Anything else?
No, yeah.
Okay, what else do you have? You can be excused, man. Thank you. What else did it add?
I really don't want to call him as a witness, Your Honor. I think that it's sufficient from what his mother, or the listed from his mother for the court to look at his conditions. And then, of course, I mean, I guess I can just like briefly call him as a witness. Frazier.
Yeah, I think, have you been sworn in already? Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Go ahead.
You heard your mother testify about your banking account, savings account, checking account. How much what's access to you? Before it's money in a bank or something that you can access.
800 to 1,000.
Would you make all of your court appearances, show up to court?
Absolutely, no question.
And if the court orders of no contact with the alleged victim in the case, you abide by that?
Absolutely. Absolutely.
And again, if the court orders that you install and maintain a GPS device, you would do that?
That's not a problem. Yes, sir.
Pass witness.
Didn't Judge DeRuin order that you have home confinement and a GPS monitor?
Brandon, if you could be clear.
The judge that arraigned you when you set the
Yes, sir.
question is, when you were set the $100,000 bond, did it include the conditions of home confinement?
Yes, sir.
Did it also include the conditions of a GPS monitor?
Yes, sir.
All right. So what efforts have you made to raise money towards the bond as it is currently set?
I've been in jail, so I didn't actually find out about a lot of this till the end of February.
Right. So you currently today, you haven't done anything to try to sell off those assets or find out how much money you've got in your bank account, correct?
Yes and no. I put a few things online, but I didn't get the chance to really go anywhere with it.
So you really haven't had the opportunity to try to put together funds to try to make the current bond amount. I made the representation to the court through my questioning of your mom. She had 2 different jail incidents. Is it true that on April 13th, that would be Saturday, that you were involved in a physical fight with an inmate by the name of William Woodley?
Yes, sir.
And that all occurred knowing that you were coming to court. You knew you were coming to court, right?
29th, yes, sir.
Yes, sir.
I didn't want to fight.
But it happened.
Yes, sir.
Likewise, you also had an incident soon after you came into custody where a nurse alleged that you treated her improperly.
That was actually male nurse, sir.
I'm sorry. A nurse alleged you treated them improperly. That's the accusation, correct?
That is the accusation.
Has there been a finding by anybody on that? Meaning, once the issue has been done, has there been a finding by a court or anything there at the administrative level?
I asked for them to check the camera systems. No, sir. They didn't want to do that.
Right. Did you receive disciplinary action?
3 days restrictions.
So the answer is yes. You're
Yes, I did.
disciplined for that conduct.
Sir.
No further questions of this
Didn't
witness,
sign that
Judge.
form.
What
I didn't actually sign that form.
was the 3-day restrictions for the incident with the nurse or for the incident with the other inmate?
No, it was for the incident with the nurse, the male nurse.
Was that when you were going through intake or when was that?
No, it was about 1 a.m. I was having pain and they told me they refused to see me for the pain. And I just quit talking. And then next thing you know, I'm being rid of them.
Okay.
Say it again. Next thing you know, what?
Next thing you know, he called the jailers to come in. They didn't hear our conversation, but the write-up alleges I was yelling. And next thing you know, they're writing me up because I wouldn't talk because I didn't know what to say. I don't disrespect them.
Very good.
Disrespected. And I guess there's no incident report that can be tendered. So
I can if you want, if you're not going to object.
again, we're going down a side trail here. And obviously, jail is what it is.
Anything else?
No.
Anything else?
Not from the state, Judge.
Right. The issue on bond is dealt out clearly under Article 17.15 of the Texas Code of Criminal Procedure. The rules for setting amount of bond shall be sufficient to give reasonable assurance that the undertaking will be complied with, that is, appearance in court. The nature of the offense and the circumstances under which the offense are committed are to be considered, including whether the offense involved violence as defined in Article 17 that the grand jury has rendered in true bill states that you drove by and videoed the residence of the complainant and your conduct would cause a reasonable person to be placed in fear of bodily injury or death and feel harassed, annoyed, alarmed, abused, tormented, embarrassed, or offended. Also, that you knowingly engaged in conduct, namely a text stating the defendant would assault the complainant and that would cause a reasonable person to fear. There's a probable cause affidavit that is applied in this case that the court is going to, the probable cause affidavit, which and the court has highlighted the portions that the court feels are relevant in this hearing. That on August 8th, 2023, the complainant receives a text message from the defendant that he knew where she lived and has homies that live 2 doors down who are watching her. Now, it also states that the defendant has video recorded the complainant's house and passes by ensuring that she knows he is here. He is there. In this video, the defendant is driving a moving truck and states, "You think I'm crazy now? Y'all going to see how big my balls are."
It is such a strange thing that this man is asking us to think about. Perhaps she was mistaken when she said that he had a couple of his homies down the street.
If you keep my kids from me, you put yourself between me and my kids. I'm going to stop your face in, homie. Watch. Now, this video, do you have a copy of that?
Yes.
Okay. Probable cause affidavit certainly is more than concerning. It's very threatening. And we are on an issue apparently where these two have children together. And there's obviously emotion here involved. But the grand jury has reviewed this case and indicted you for the 3rd-degree felony of stalking. Thus, there are marching orders that are normal and customary for this type of offense. Your bond is at $100,000. I'm going to reduce it to $75,000 because this court is not aware of criminal history.
There's been arrests, but no convictions.
Convictions are what are the key here. I can also, as a condition of a bond, under Article 17 for a bond involving stalking, if you post a bond, you shall not communicate with the victim, go near the victim's house or workplace, nor go near a school or daycare facility where the victim's children attend until this gets resolved. Also, you must have a GPS device that shows where you are at all times, and you shall not go near the victim or the children unless the other courts have reviewed this case and deemed that visitation necessarily ordered. Until this case gets resolved, what we have to do is freeze the action to ensure that further harm does not occur and additional wrongdoing is not added to this case. You're looking at up to 10 years in prison right now. Do you understand? On this charge. So that is serious. What other conditions of probation of bond would be necessary?
Based upon the discovery, the state would ask for a drug patch. And what I mean by that, Your Honor,
It says that he failed a drug test. What was, did not pass a court-ordered drug screening. What was that?
they took a hair analysis, Judge, which my understanding.
Why was that done?
It's part of their court proceedings that were ongoing in the 88th District Court there in Hardin County.
Okay.
The result shows that he was positive for cocaine, positive for oxycodone, positive for THC. So based upon those results, I would ask that there be a drug patch additionally as a condition of bond.
Like, again, Your Honor, that's an additional expense. Perhaps the court could drop the bond if we're going to have a drug patch as well.
Well, I've read, you've read it. You've got a copy of the indictment, the probable cause affidavit. You've got a copy of that. If you don't, I've got a copy for you. So we've got to, these are most serious accusations, most serious. And we're not just talking about the mother of the children, but children are necessarily involved here. You're their father, right? I'm a father. I can't imagine putting my children into a position where they're afraid or in an environment like this where their mother feels threatened. It's for you to fix. You got a mess here. You got to figure out. But what we got to do is ensure that harm is not done from here on. But these are quite serious accusations. And what we're trying to do is to separate everybody until we can resolve this under the rules of law as soon as we can do it. And that means everybody's going to move to the corners until we can resolve this as soon as we can.
We set it for announcement.
What you want to announce now?
I'd like to really have an opportunity.
How much time? 3 weeks?
Yes, sir.
Okay, I'll reset 3 weeks announcement.
Now that the homie who wants to show everyone his giant balls has been and gone, this next case is pure Southern gold, where we have a hillbilly who thought it would be a good idea to abuse Judge Stevens' female friend. I think this guy is the one that has the big balls, no brains, but huge.
In the state of Texas versus James Gregory Westbrook. You are Mr. Westbrook?
Sir.
There is a motion to revoke probation that was filed, sir, on March 21st of this year. In summary, this motion alleges that on September 17th, 2018, in this criminal district court, you were sentenced to 10 years in prison. That was suspended. You were placed on regular probation for 10 years for evading arrest and detention with a motor vehicle, a third-degree felony. Is all of that true, sir?
Yes, sir.
Allegation 1 states, number 14 states, among other things, that you shall be courteous and professional at all times, especially when with interacting with court officers and probation officers and staff. Are you clearly familiar with that?
Sir.
Allegation number 1 states in a telephone conversation with the probation officer, with Ms. LeBlanc, who is one of the most professional and courteous people I know, and I've been around a long time. That you failed to conduct yourself in a professional and courteous manner, especially with her, in your vulgar statements. You can take your probation and tie a pretty little bow around it and shove it up. You know what you said. I've already reported you to federal authorities about F-word up my extraditions. Did you really say that?
I may have. She called my father several times.
You're not calling her a liar, are you? She says that's what you
No, I'm
said.
not calling her a liar, but I'm just saying that.
What have you lost your memory?
No.
You either said that. Do you
Okay, I said
do you
it.
use this
I said
this type of
I'm not gonna
vulgar
argue
language?
about it, but I said
When I speak, you stop. You use this kind of vulgar language in a regular way, do you? You can't even remember? Or is this is this a unique situation? Do you do this all the time, or was this an extraordinary event?
do you want the explanation and answer?
I just asked you a question, yes or no. Do you do this normally, or is this an extraordinary event?
It's extraordinary event.
You should remember it. Do you remember it or not?
Yes, I do.
You said that to her.
Yes.
Do you understand what the probation office does? Do you
Yes,
even
I
know
do.
what they do? They try to help you be successful on probation. Were you here when I was talking about the 85% success rate we have,
Yes, I heard.
which is twice the rate of the national average, which is 70%? We're at 85. I mean, they are a dedicated group of professionals. I'm honored to be working with them. I've worked with them for almost 18 years. I worked with federal probation officers for 20 years, and they were great. These are no less capable. You would be that rude to this lady who's dedicated to your success. That's what's ironic. Is this allegation true or not?
True.
Are you pleading true voluntarily and because it is true?
Yes, sir.
Allegations of probation, that's enough to grant this motion to revoke probation. Your probation can be revoked. You can now be sentenced to no less than 2, no more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
So,
Is there agreement on this?
Yes, sir.
When was
5
that?
years TDC.
When was that done? I don't have it up here.
Well, that was on the plea papers that are in the
Okay,
computer.
well, okay, that's still working. Let me see the percentage rate. As far as I know, you have just this one felony conviction in this court that you're on probation for. Would that be right?
yes, sir.
Your Honor, since that PSI, he has had convictions out of the state of Georgia. Based on the first motion to revoke, those were the allegations alleged in
I was going to get through
Georgia.
the misdemeanors here because it covers about 3 pages.
Yes,
How
sir.
many
He also
misdemeanors?
has another, I believe, state jail felony out of Chambers County that occurred after he was released from Jefferson County or something like that.
I was arrested for all this. When I got put on probation here, I still had warrants out of Georgia, so I had to go back to Georgia. All of it. Haven't been arrested since 2018 for anything whatsoever.
But your Chambers County case that
Chambers
occurred
County,
before
I left-
this.
No, it happened the same day.
Okay.
I got arrested. I got my report here, left from here, got my probation, left from here, went to Chambers County, transferred there, went to prison there, left from prison there, transferred there, went to prison in Georgia. Haven't had any arrests since then. Probation was supposed to have been transferred from here to Fulton County.
Went to prison in Georgia for what? For the possession of methamphetamine?
No, it's prior to that, it's stuff I've taken.
I don't see any prison sentences here.
Your Honor, those occurred after his date of probation here in Texas. Yes, sir.
Well, why are they in the motion to revoke probation?
They're in the motion to revoke that was previously disposed of in October of 23.
Committed the offense of fleeing or attempting to elude out of Carroll County, Georgia. Committed the offense of fleeing to elude. Those were two offenses on two separate days. Looks like one July 9th, the other July 10th of 19.
I believe those are the first amended motion to revoke community supervision that was filed on 8
How many
2.
How many
2019.
misdemeanor convictions do you have, sir?
Excuse me, sir.
How many misdemeanor convictions do you have?
I have no idea, sir. Probably 10,
14.
14.
How come I know more about your life than you do? Are we talking about driving while under the influence, theft by shoplifting, simple battery, family violence, disorderly conduct, child abuse, driving under influence, willful obstruction of law enforcement officers, driving under influence of alcohol, driving without a valid license, disorderly conduct, willful obstruction of law enforcement officers, evading arrest or detention, among other things. So we're trying to, this was 5 years, is that right?
Yes, sir.
After all of this criminal history and then the obnoxious insults to this lady, I'm supposed to cut you a break? You're looking at 10 years in prison. She deserved better than that. All of them did from you.
Apologize for being.
Oh, that takes it back. I'm sure she feels much better for all the time that this happened. Let's see, this happened when? On January 10th, 10 months ago. You're apologizing now? I'm not taking this deal. No way. You don't treat people who work for me like that and serve the county. No, we'll just have a hearing and let it rise.
Can we sell it now?
I'm not making a deal with you.
It's just not.
You're rude, obnoxious. If you treat someone who's really, their commitment in life is to help you, if you would treat them that way, what would you do to someone else? Shame on you. Set this for a hearing. We'll decide where I go. But I'm not accepting a deal of 5 years. Not for your obnoxious, rude, selfish attitude. That hurts people. You don't seem to care. But I'm going to ensure that justice is served. Thank you. We'll set this for a hearing.
Thank you for watching my episode till the end. I want to say thank you to my subscribers for helping my little channel get to here. If I could, I would kiss you all passionately, but instead, I'll feed this cat some more. If you like my selection and how I edit out the boring parts, please like and subscribe and become a subscriber of mine and some very fat cats. If you would like to check out a selection of my episodes, please click on and save the playlist on screen now to your YouTube. And I'll get to feeding this cat, who really is just very, very big boned.